us. And we'll begin with Ms. Anand, and if I'm mispronouncing that, I hope you'll correct me.
You pronounced that perfectly, Judge Smith. May it please the court, Easha Anand for Plaintiff Appellant Dennis Wayne Hope. I'd like to reserve 5 minutes for rebuttal.
Yes, that's fine.
Mr. Hope alleges that for a quarter century and counting, he has spent virtually every waking minute alone in a cell smaller than a compact parking space. His only human contact is with the guards who strip search and handcuff him, and he leaves his cell only to exercise, which he does in another cage. He's alleged that more than 2 decades of isolation have led to chronic pain, hallucinations, and thoughts of suicide, all of which defendants are aware of. And those allegations are more than plausible because research demonstrates that prolonged solitary confinement is physically and psychologically devastating, and because long-term solitary confinement has been tried by a handful of prisons over the centuries and always abandoned when it drives prisoners to madness.
Are you contending that long-term solitary, we can worry about later how to define long-term, but are you saying that long-term solitary confinement is per se unconstitutional, or is it only as it relates to the facts of your client?
So we're only alleging in this case we're arguing that these specific defendants were deliberately indifferent to this particular plaintiff's suffering. We've also made an argument that if you look at the definitions of unusual that the Supreme Court has adopted, long-term solitary confinement fits within those definitions, but we don't argue that that means that defendants could never use long-term solitary confinement. Does that answer your question, Judge Smith?
It does, thank you.
So perhaps I should start with our first theory of Mr. Hope's Eighth Amendment claim, which is that defendants know of the devastation that decades of solitary confinement have wrought and continue to wreak, and yet ignore it. So in Fussell versus Vinoy, this court found that it was, quote, more than plausible that, quote, decades of extended lockdown have caused the serious mental health problems that the plaintiff there alleged, and that it was, quote, clear that such allegations are sufficiently serious to invoke Eighth Amendment concerns. The same is true here. So on the objective prong of the deliberate indifference test, we have both Mr. Hope's allegations about what he has already suffered to date, plus the universal consensus that any sort of long-term solitary confinement, let alone for more than 20 years, causes physical and psychological harms.
Can you summarize for us what is wrong with the committee evaluation that periodically occurs of his solitary confinement? What violates due process and so forth? Can you sum that up for us?
Sure, Your Honor. So Mr. Hope has alleged that these reviews are a total sham for 2 main reasons. The first is that everyone involved in the process totally disclaims any authority to make a decision. So he's not going before a decision maker who's authorized to make the sort of, to actually relieve his injury. And again, these are folks who on paper have the authority to make this decision, but are choosing to pass the buck. And the second reason is that at these committee meetings, it seems as though no one is actually thinking or talking about Mr. Hope. So he alleges no one reviews his file. He alleges that instead they make small talk about everything else under the sun, including the availability of firewood. He alleges they don't listen to his statement. So those 2 pieces mean that these aren't really periodic reviews in any meaningful sense, because to have a review, you've got to have someone who acknowledges they're empowered to make a decision, and you've got to have them actually think or talk about the subject at hand. So those are the problems from a due process perspective. And of course, from an Eighth Amendment perspective, even all the process in the world can't cure an Eighth Amendment violation.
And let me go back to the process though. What is your best case? Because I've always learned that due process is notice and the opportunity to be heard. Certainly in my life as a lawyer, I've appeared in front of judges, some who were listening more in my view and listening less in my view, obviously my view, and I'm not insulting any judge. But I never claimed a due process violation for the client on those bases. So what is it exactly, what's your best case for the proposition that a judge sort of or the committee in this case, but the listener, the person who is the opportunity to be heard, the hearer, is kind of blowing you off. Where is that case? What is the best case on that?
So I think it's a conjunction of two cases. So Hewitt versus Helms at note 9 says that the key question is whether you have a meaningful opportunity, and you certainly don't have a meaningful opportunity if no one's listening to you. And then this court echoed that in Schaefer and said that the key question is whether there's an actual opportunity to rebut, which again requires going before someone, the judges you appeared in front of, Judge Haynes, presumably didn't tell you, well, I don't really have any authority to make your decision. You got to ask the guy down the hallway, even though on paper, I'm the one empowered to hear your case. And I think that would have been a very, very different case had they said that to you. And so in order to have this sort of meaningful review, you've got to have an opportunity to rebut what the state is putting in front of, the reasons that the state is saying that you need to be continued in solitary confinement. And that simply can't happen if you're appearing in front of someone who's telling you, I just don't have the authority to make any sort of decision here. And I'll also note that in this case, each of the defendants is empowered on paper. So this isn't a situation where he's just appearing before the wrong actor. This is a case where everyone's empowered on paper to make this decision. Some have even acknowledged to him we're empowered to do this. And yet he's being told over and over again, you know what, I don't want the responsibility that comes with making this decision. So to turn back for a moment to the Eighth Amendment argument, just to kind of tie the loop on the evidence that we've got for the subjective prong of the deliberate indifference test. We've got first Mr. Hope reporting that he has reported his symptoms directly to defendants. Second, we've got the fact that defendants know that inmates in solitary confinement in the Polunsky unit are prone to attempting suicide or engaging in self-harm. Third, we've got the fact that the sort of risks of this kind of super long-term deprivation of human contact should be apparent to any correctional officer. And fourth, defendants' own policies, which require a break after just 15 days of solitary confinement, make clear that defendants are aware of how dangerous solitary confinement for more than just a few weeks would be. So that's our sort of first theory of why Mr. Hope's allegations violate the Eighth Amendment. I'm going to talk a little bit about our second theory, which looks at the kind of first principles definitions of the terms cruel and unusual. I'll take the unusual prong first. The Supreme Court has put forth 3 definitions for the term unusual, and under any of those definitions, Mr. Hope's treatment qualifies. So to start, solitary confinement of the sort that Mr. Hope has endured was unknown at the time of the founding. So just one jail in the young republic had any sort of systematic use of solitary confinement, and as late as 1827, so decades after the Bill of Rights is passed, an inspector from that jail testified that no inmate had spent more than 16 months in solitary. If we want to widen our scope and do the sort of Bucklew inquiry of whether a punishment is novel or long disused, John Stiniford, the professor whose definition the Bucklew court adopted, tells us that long-term solitary satisfies that requirement. Judge Smith, you asked at the outset whether this would amount to a categorical prohibition on long-term solitary confinement. I don't think so, but defendants haven't made any argument here to that effect. So that is, in a future case, defendants could argue, for instance, that Bucklew says if you're challenging the way a sentence is executed rather than the sentence itself, it's not cruel if there's no feasible alternative way to do it, right? And so I'm not prejudging how that argument would come out. Defendants haven't made it here, presumably because, at least on the allegations in the complaint, Mr. Hope has alleged he's not an escape risk anymore. In fact, a committee of correctional officials looked at his file in 2005 and said, you're no longer an escape risk. But should the case come up, and again, having a little trouble imagining it because this country has done without long-term solitary confinement for most of its history. Most states today don't use it. Correctional officer amici tell you that long-term solitary on the order of decades is just not necessary to run a secure prison. But should the case come up where it really was infeasible to hold someone without the use of decades of solitary confinement, Bucklew potentially would give defendants an escape hatch. Now, again, I don't want to concede that that test would necessarily apply in this setting. I'm just saying, to reassure Your Honor, that there are a whole set of arguments defendants simply haven't made in this case, presumably because there's no factual basis for making it, that would ensure that there would be some sort of case-by-case determination of each instance of long-term solitary confinement.
And so let me ask you this, specifically, if we were to rule in Mr. Hope's favor, and obviously I'm not saying we will or won't, just if we were to, what specifically are we to direct the district court to do? Where would that take you? And where would that take our opinion?
Certainly, Your Honor. So at the most basic level, all we're asking for is the chance to get into discovery, right? So on the kind of deliberate indifference test, we'd of course need to prove both the sort of objective prong, how horrifying this has been and how much it has damaged Mr. Hope and how much damage it risks doing to Mr. Hope. And on the subjective prong, we'd have to show not only that defendants should have been aware of, but that they actually were aware of what was happening and did nothing. On the sort of second Eighth Amendment argument, we'd have to demonstrate what these conditions look like and their cruelty. And like I said, there would probably be a whole set of arguments the state would make about how categorical a rule should be adopted. If it turned out, for example, that Mr. Hope's allegations that he's not an escape risk, which you have to take it as true at this junction, and certainly he's pled not only that he thinks he's not an escape risk, but that correctional officials, security experts think he's not an escape risk. But if it turned out that he were an escape risk, there would of course be some discovery on that, and there's a whole set of legal arguments.
But to kind of sum up, I mean, your prayer at the end of the brief is to reverse. But I'm kind of trying to get into a little bit more like, okay, we reverse. The district court likes us to know a little more than that. What you're saying is we reverse and send it back for kind of the next phase of the litigation.
That's
so
right.
We send it back, you guys do your discovery, they can then file another motion, a summary judgment of whatever, and you address it then. So you're not saying y'all win outright, you're just saying you just reverse the dismissal and have a chance to kind of take the next step in litigation.
That's exactly right, Your Honor. All we're asking for is the chance to get into discovery and prove this case. Like I said, there are a number of factual points at which the state could produce evidence that would rebut some of the allegations in the complaint. But this complaint, as drafted right now, clearly states an Eighth Amendment violation in several different ways. Is that enough granularity, or is there?
Yeah, I guess one other thing I'm wondering, when I was in law school, my tort professor would always say, what really happened here? So I kind of wonder that here, we're this far along in this case, and I guess I'm wondering why they're still keeping him in solitary despite all of this litigation and, kind of where we are. I guess I'm just wondering what about this person is leaving him in solitary despite, all of this litigation, including where we are right now.
So, Your Honor, I think that's actually probably a question better directed to opposing counsel. I don't know the answer. And I'll just say that we're, it may seem like a lot, but we're actually at a very preliminary stage, right? He's just filed a complaint and it's been dismissed. And so what we're asking for here is not that you write an injunction that gets him out of solitary. All we're asking for is a chance to proceed into discovery, because what he's alleged is a sort of historically anomalous and really, really serious and should raise Eighth Amendment concerns for any judge reading the complaint. And so I don't know the answer to why he's still in solitary. As he alleges in his complaint that as of 2005, the Security Designators Committee removed the escape risk classification from his file. But I just want to push back on the premise that we're somehow so far down the line in litigation that this court's opinion is going to somehow sort of let him out tomorrow. It won't. It will allow him to kind of get some discovery and continue to make his case. So at this preliminary stage, as I said, drawing all inferences in Mr. Hope's favor, this court must reverse the district court's dismissal and allow proceedings to continue. And so if there are no further questions, I'd like to save the rest of my time for rebuttal.
Yes, Ms. Anand, you've saved your time for rebuttal. Thank you. Mr. Steene?
Thank you, Your Honor. I guess one other thing I'm wondering, when I was in law school, my tort professor would always say, what really happened here? So I kind of wonder that here, we're this far along in this case, and I guess I'm wondering what about this person is leaving him in solitary despite all of this litigation.
Thank you, Judge Smith. May it please the court. On appeal, Mr. Hope offers an array of new arguments and original research, but the district court had to consider only the complaint and the documents attached to it. That record shows that Mr. Hope's complaint was correctly dismissed because his continued administrative segregation serves a valid penological purpose. In addition, Judge Haynes, the record also answers your question as to what really happened here. And I'll be very happy to discuss that as much as you'd like. But with this court's permission, I intend first to address.
Well, the reason I ask that is, I recognize we've got to decide the case based upon the law, and we will do that. But you, as the lawyer for the defendants, can work with Mr. Hope's counsel and try to reach some sort of accord or accommodation, because you could conclude that 25 years of solitary confinement, even if it's not per se violation, is a lot. And as bad as this man's crimes have been, there's been far worse, and those people are not in solitary confinement for 25 years. So I'm just a little bit struggling to kind of why we're here.
No, I completely understand it. In fact, that brings me quite nicely onto the first point, which is the Eighth Amendment claim. And here, Mr. Hope hasn't stated a valid Eighth Amendment claim, and certainly hasn't satisfied the second prong under Farmer, because he has not alleged, and in fact, the record does not show, that the continued administrative segregation is not totally without a penological justification. That's the language that's used in Rhodes v. Chapman at 346. That's the language that's also used in Farmer. It's quoted in the blue brief as well. And in fact, my friend on the other side just mentioned Fussell v. Vanoy. And in that case as well, the court distinguishes between a reasonable policy judgment on the one hand and deliberate indifference on the other hand. And so hopefully, Judge Haynes, I'm about to answer your question and one of Judge Smith's questions together, because the Third and Fourth Circuit decisions, the two Porter decisions that Mr. Hope asked this court to adopt, actually agree with the defendant's position in this case. And I'm going to quote from Porter v. Clark, the Fourth Circuit case, and that's at 362 to 363. The court said, "We believe that a legitimate penological justification can support prolonged detention of an inmate in segregated or solitary confinement, even though such conditions create an objective risk of serious emotional and psychological harm." So, that also mirrors the Supreme Court's discussion in Wilkinson v. Austin, where it twice says at 224, at 229, that long-term solitary confinement may further a valid penological interest in protecting other inmates and other members of staff. The Fourth Circuit also pointed out the 11th Circuit has taken a similar approach. The Seventh Circuit apparently has taken a similar approach, according to Porter. And as I mentioned before, the Third Circuit in their Porter decision at 351 took a similar approach. The Fourth Circuit...
On the specific facts here, and I understand the facts have not been developed, but is it or is it not an element of this punishment that this particular prisoner has threatened to escape, or has threatened otherwise to cause harm within the institution?
Well, precisely right. So the Fourth Circuit ended up not reaching the issue because it was waived, whereas although my friend on the other side has suggested otherwise, we actually discuss valid penological interests at page 12 of our red brief. The Third Circuit found no evidence whatsoever in the record to support the notion of a penological interest. But Judge Smith, as you point out, there were the two escapes ending in 1994. But more importantly here, the court doesn't need to worry about the 1994 escapes. The court doesn't even need to wonder what really happened here, because the record answers it, in particular, ROA 23. So ROA 23 is Mr. Hope's level one grievance form that he submitted with his complaint. And in that grievance form, he complains that he's still being held. And again, he makes his similar allegations about a sham hearing. And in response, and this is at ROA 23, the SEC says, "The State Classification Committee's decision was to remain you on current status until 12/16 on the basis of escape risk, staff assaultive, and weapons possession. No further action is warranted at this time." And on the next page in the level 2 grievance, Mr. Hope doesn't say, well, actually, that's wrong. He doesn't say, I'm not an escape risk anymore. He doesn't say, I haven't recently engaged in staff assaultable weapons possession behavior. He just says, I'm filing this level 2 grievance because I want to be able to get into court now. So you have this undisputed element of the record where the State Classification Committee has provided its justifications. It's provided a contemporaneous...
But I thought they removed his escape status in 2005. That they thought he was an escape risk.
That's certainly correct, but an escape risk is not a one-way street. Just as it can be removed, it can be added back if the prisoner engages in violent behavior or engages in behavior.
And what happened between 2005 and the response to the level 1 grievance that brought him back in the escape risk bucket?
I'm afraid I can't tell you because that is not in the record. But like I said, what is in the record is that there is this new finding. And even if there weren't that finding, there was a finding of staff assaultive behavior and weapons possession. And again, Mr. Hope, in his grievance form, in his level 2 response, does not deny that. And so the court has no obligation under those circumstances to just agree that there's no valid penological purpose, because the State Classification Committee has provided it, and Mr. Hope, in his grievance form, and certainly with respect to the staff assaultive and weapons possession, has not refuted that.
Okay, what about stepping aside from the pure solitary confinement, this mistreatment of him, putting him in feces-covered jail cells and so forth? How do you justify that?
Well, certainly that is undeniably not ideal behavior, although in these circumstances, I question whether he's named the right defendants. For example, it's unclear whether the SEC members, number one, were aware of those particular conditions, and number two, had any power whatsoever to fix it. Again, that fails under the...
But he named the people that moved him there as well. I mean, he's got a bunch of defendants here. I realize not every one of them may have contributed to the moving him to the feces cell, but, he did sue people that might have. And so, again, I mean, we're at an early stage in the case, and we have to give liberal construction to pro se briefing in the district court. Why isn't that enough given the Supreme Court's recent decision on that?
Well, that might very well say, with respect just to Major Reese, be sufficient to allow a complaint with regard to that particular aspect of the solitary confinement claim to go forward, but it wouldn't allow claims to go forward as against, say, the warden, as against the SEC members, as against Mr. Skesser, as against Ms. White. It wouldn't allow any of those claims to go forward. And so, insofar as that's the only part of the claim that's left, the court should dismiss the remainder and then vacate or reverse and remand for the court to consider just that claim alone. But just briefly, just to make the...
Would you speak to the retaliation claim, because it seems to me that there's some substance to that claim. Tell us why, in your view, that's without merit, if that's still your position.
It is, because it is. The both parties agree that a retaliation claim can be stated by setting out a chronology that plausibly creates an inference of a causal connection with retaliation. And that hasn't happened here. We pointed that out in our red brief. And in response, Mr. Hope said that, I believe this is at Grey Brief 19, said that Mr. Hope had alleged that immediately after filing his grievance, he began his weekly moves. That's not what the record says. The record, which is the relevant part, is at page 70, says that before he wasn't being moved, and at some point after, he doesn't say when, he then started being moved on a weekly basis. What he does say is that he was being, is that at the time of his filing, and this is record 70, he had been moved once a week for 263 weeks. And doing a little bit of math, given that the given that the complaint is dated June 2018, that means he started getting moved 5 years beforehand, which puts the moves in 2013. And that's well over a year after the February 2012 incident. And Mr. Hope alleges that these facts are on par with those in Butts v. Martin, but that's simply not the case. In Butts v. Martin, and in many, if not most, of all the other cases that Mr. Hope cites, the retaliatory act took place the day after, and sometimes the day of, the alleged protected conduct. So in those circumstances, it might very well be plausible that there is a chronology and that there is a causal connection. But when we're talking about conduct that took place well over a year afterwards, that happens routinely in prisons, especially when prisoners are an escape risk, it's simply not plausible to say that weekly moves starting more than a year afterwards can state a claim for retaliation. And in fact, as far as I know, Mr. Hope has not cited any case that has the separation between the protected conduct and the retaliatory act that far apart. But turning briefly back to the Eighth Amendment point, because my friend on the other side mentioned some originalist points and mentioned some contemporaneous arguments as well. I just wanted to briefly touch on those before, if I have any time left, quickly discussing the due process claim. The originalism arguments seem to be somewhat contradictory. Just take, for example, the assertion that solitary confinement was unheard of at the time of the founding, but in Medley, the 1890 case that Mr. Hope cites discusses its use in England well after the time of the founding. The Shapiro article that Mr. Hope cites, the Harvard Law Review article, mentions that it was being used in the 1890s and the early 19th century in America. My friend on the other side also suggested that only 16 months might be the most that anyone was put in long-term solitary confinement. But on Blue Brief, page 33, Mr. Hope also suggests that maybe some long-term solitary confinement had been going on for decades. And so this analysis founders pretty quickly, because there doesn't seem to be even a consensus as to exactly how common solitary confinement was.
Is there anyone else in the Polunsky unit who has been there that long?
I'm afraid I don't have that information.
Okay, and so I mean, why wouldn't we let some degree of discovery go on to kind of look at that? Because you talked about the troubles in his crime and the fact that he tried to escape in 1994. I'm sure there are other criminal defendants. I know there are that have worse criminal offenses, and that have certainly done other things over the years in the jail and have not been put in solitary confinement. So why wouldn't they be allowed to develop that to show that maybe he's being singled out for reasons unrelated to the actual proper considerations, like that he might escape, and it's retaliation or it's whatever. So I guess I'm not understanding why we don't allow at least some discovery on this to try to flesh out some of these facts that we don't have in this record.
Well, because that's not the test, Your Honor. The test is whether or not there is a total lack of penological justification for the conduct. The record shows, an undisputed portion of the record shows, that there is a legitimate reason. My friend on the other side didn't want to proffer other reasons why he might be being kept in. And so again, those reasons remain undisputed. And let me give you another example.
At a motion to dismiss stage, we accept the facts set forth by the plaintiff. We don't, again, I mean, I could understand maybe at the summary judgment stage that maybe we get to this point of, the if and or whatever. And so I guess I'm just trying to understand, again, this early stage, why we have to believe your version of the facts.
Well, again, they're not my version of the facts. They're the facts that Mr. Hope decided to attach to his complaint. And so let me give you an example. In fact, I can give you two. One of them is Lau v. Johnson. It's cited in Wilkerson, and it's also cited at ROA 151. In that case, this court affirmed a dismissal of an Eighth Amendment claim as frivolous by relying on the response from officials in the grievance form that was filed with the complaint. So that's one example where that did happen. Another case is Chevaria v. Stacks, and I do apologize, that's not briefed, so I can't give you a cite to that. It's 102 Federal Appendix 433. There was an Eighth Amendment claim based on a complaint of constant cell illumination. The court affirmed the dismissal as frivolous because the conditions were reasonably related to a legitimate penological interest in guard security. And again, that's without any fact development whatsoever. I should point out, though, if for full disclosure, Judge King, you did dissent in that case, so perhaps it's not the best case. But that's the reason why, because there is here an undisputed, valid penological interest that the court has recognized in Wilkinson v. Austin and that remains undisputed on the record. Let me give you just one other example, Judge Haynes. Imagine this is a contract case and the party, the plaintiff says, we agreed I would buy a widget for $15, and he attaches the contract to the claim and to the complaint. And the contract actually says, it says $17. I think under those circumstances, even at the motion to dismiss stage, no one would have any problem with saying, well, actually, you've attached the contract or relying on this contract. It says $17. We have no reason to conclude otherwise. And it's the same situation. It's exactly the same here. And speaking of the record and also speaking of Lau v. Johnson, while I still have a few minutes left, I wanted to touch on the due process, the due process argument. So just briefly, the nub of Mr. Hope's complaint that he's not being provided any process is that they don't consider his current attitude or behavior. He says that at ROA 72 to 73, I think he says, the only reason I'm ever given is my 1994 escape, and that will never change. And I believe that's at ROA 75. But again, ROA 23 shows that is simply a bare conclusory assertion masquerading as a factual allegation. And Ashcroft v. Iqbal, Twombly, they all say that you don't have to credit it in those circumstances. And again, that's exactly what the court did here in Lau v. Johnson. It looked at the grievance form. It said, well, actually, you have been given reasons. You have been provided with process. The court did not err in dismissing the case as frivolous. And so that's exactly what you have here. Mr. Hope has been given the reasons. It's obviously true that he doesn't like those reasons, but he's been given notice and he's been given an opportunity to respond. And as you can see from the grievance form, he chose not to use that opportunity to say, no, none of this is right. This is based on outdated information. My classification was changed several years ago. He simply says, I don't want to take this any further. I just want to go into court. So again, as in Lau v. Johnson, there is an undisputed portion of the record which shows that that Mr. Hope has been provided with the process, assuming that he is entitled to it. Given that I have maybe one or two more minutes, I wanted to briefly touch on the standing argument and the ex parte Young discussion, because that was briefed, and my friend on the other side somewhat alluded to it in passing, so hopefully I can just get through it quite briefly. The problem here is that Mr. Hope's argument about who has authority to do what and whether he's relying on those assertions keeps changing. So let me give you an example. At ROA 72 and ROA 74, he alleges that Five-Ash and Bennett do not have authority to release him. But then in his district court brief opposing the motion to dismiss, he says he relies on the defendant's assertions that they have no power to release him. And that includes Five-Ash's statement at ROA 74 that it's the director's call. Mr. Hope changes position on appeal and says at Grey Brief 14 to 15 that they do in fact have the power to release him, and that he's simply alleging that those assertions are false. But of course, he said the opposite in the district court. So if you take him at his word in the district court that none of the defendants have the power to release him, then obviously all of the defendants are the wrong defendants because none of them can redress his injuries. And if you agree with him that none of them have the power to release him, then you also have an Okpalobi problem. So an ex parte Young problem, because the first prong of Okpalobi, or as it's more recently been used in, say, Texas Democratic Party, the Abbott, the merits panel decision, which Judge King, you were on, they don't have the power to enforce the challenged law. So they're the improper defendants there. But if you assume that the state classification committee does have the final say, then of course the court can reach the merits. But in that instance, ROA 23 is really all the evidence the court needs, even at the motion to dismiss stage, in order to conclude that he has the process to which he's due. So whichever way he decides to come out in his position, the court should affirm the dismissal of his claims. Unless the court has any further questions, I will yield the small portion of the rest of my time.
Thank you, Mr. Steene. Ms. Anand, you've saved time for rebuttal. I'd appreciate it if you would first respond to what Mr. Steene had to say on the retaliation claim.
Thank you, Your Honor. I'd be happy to start with the retaliation claim. So Mr. Steene does a back of the envelope calculation, assuming that the 263 moves happened exactly every week. I think it's fair on a pro se pleading to say that weekly doesn't mean precisely every week. And we know, for instance, he was in the black mold cell for 13 days. And so I think
specifically, could you respond to his argument about the 1 year lapse or 1 year delay?
So I don't think there was a 1 year delay is what I'm saying. He calculates a 1 year delay by saying 263 moves on a weekly basis, but we know they weren't precisely every week, right? Some of them lasted as long as 13 days. Weekly is sort of a colloquial way of referring to a very frequent move that happened approximately every week, sometimes every 2 weeks, sometimes more frequently. And so I don't think it was a year after. He doesn't say the exact amount of time that elapsed between the grievance and the start of the cell move policy. I think it's a fair reading of the complaint, though, when he says, before I was not being moved, after I was being moved, to assume that it happened close in time. And Your Honor, if that's the only concern, that he doesn't allege the precise number of days that elapsed between filing the grievance and the start of this retaliation, he should at least be given leave to amend to list the number of days. And again, it's not, you can't just say 263 weekly basis and assume you mean exactly once a week, when we know at least some of the moves, like the move to the mold covered cell, lasted 13 days. I'd like to also respond, if I have some time, to the citation of ROA 23, this legitimate penological purpose argument, and the originalism argument that the opposing counsel made. So as to the first, ROA 23 isn't cited on appeal, and Lau isn't cited on appeal. And ROA 23, to be put in context, first, at paragraph 38, Mr. Hope alleges that even though the SCC continues to say he's an escape risk, it's not because of anything that he's done, and it's not in spite of what the 2005 designation found. They're just sort of continuing to recite the same thing over and over again. Now, again, in discovery, that may turn out to be false. It may turn out that contrary to his complaint, there's something new that happened that makes the SCC think that he's an escape risk. But right now, what he's pled is they copy paste the same thing every 6 months. They keep saying I'm an escape risk despite this finding in 2005. They keep saying that they're relying on all the stuff that happened in 1994. And I'll just note, Your Honor, that the grievances that were attached to prove exhaustion. It's not even clear the district court was allowed to require that. This court said in Torrance versus Mississippi Department of Corrections, that 301 Federal Appendix 386, that the district court can't demand this exhaustion information. It did, so Mr. Hope included it, but for purposes of this court's analysis, it's not even clear that's properly before this court. And even if it is, you have to read it in the context of the complaint, and taking the complaint's allegations is true. If indeed Mr. Hope is right that the SEC is continuing to copy paste the same reason, that doesn't mean there's some new finding he's an escape risk since 2005. It means they're just copy pasting the same thing they've always copy pasted. I'd also like to respond to the legitimate penological purpose point my friend on the other side made. As the Fourth Circuit in Porter made clear, there's a split over the way the legitimate penological purpose test works. This court hasn't weighed in on that. We would submit that the better reading of Rhodes and Farmer is that it's disjunctive. Lack of penological purpose is one way to prove. So in Rhodes says among those punishments that violate the Eighth Amendment are those without penological purpose. Farmer says no penological purpose or evolving standards of decency. But Your Honors needn't even reach that complicated question, because again, taking the allegations in the complaint is true. In a pro se case at this early stage and drawing all inferences in Mr. Hope's favor, the proper way to read this record is to say he's alleged that there is no legitimate penological purpose. Another committee has found he's not an escape risk, and the SCC just isn't functioning the way that it ought to. If I have just one more minute, I would like to respond to opposing counsel's arguments on the originalism piece, about which they said not one word in their brief. So the argument conflates two different definitions of unusual. The first one looks strictly at the time of the founding. And again, the Speer article says 16 months at the most. The second looks at the full sweep of history and asks, has this punishment ever been usual in the sense of universally accepted? And we point to one facility in the middle of the 19th century that used decades of solitary confinement. Now, this is about long-term solitary confinement. We're not talking about the 4 weeks in re medley. And opposing counsel has put forth no reason, and the briefing doesn't even mention any of the arguments about the historical anomaly that is long-term decades of solitary confinement.
All right.
I see I've run over some lesser questions.
Your time now has expired, Ms. Anand. Thank you. Your case is under submission. Appreciate the appearance of both counsel, and the court is in recess.
Thank you, Your Honor.